Jai Hind everyone, welcome again to the Patriotic IAS. Let's start our IAS PCSwala Daily Current Affairs. Today we have 6 topics that we will discuss one by one. So we will start the first topic that is coming from the government notification that they are going to record not only the data and the religion of the whole family but each of the parents separately. So this is the first news that will be part of the GS paper 1, and it could be for the human resource in under the geography. So into the geography you will read that there is the demography and other such thing. Okay, even into the this society paper you can read this under the religion. GS paper 3 also you can read all this thing. Okay, then we will study that there is a detailed news analysis on the Bharatiya Nyaya Samhita and what are the provision that is going to violate particularly violation of the constitution, and that can be challenged into the apex court on the ground of the illegalities or the violation. Okay, so it will be very detailed discussion. We will do a men's answer writing practice on this. Then we will see that there is the demand for the 100% of the recount of the VVPATs. So here we will see that do we need to 100% of the recounting? Will it not increase the burden? So what is need? Yes, there is need to increase whatever the number we are doing. Now we are doing for the 5 of the electoral booth at the assembly constituency. So we will study this under the GS paper 2 electoral system means. Okay, then we will study that the wide open, and it is on the tournament that is going to be into the Toronto, and it is for the, we will know that the famous, the leading chess player of the India and the world. So it can be asked into the state PCS. This will be general information. Again, the general information we will know about this VVPAT. This can be asked into the prelims that what is the basics about the VVPAT. Then we will study that the universities must budge on the college autonomy nudge. Here it is the discussion on the autonomy that colleges want from the university. That is very difficult to get, and our national policy on the education of the 2020 that want more autonomy for the colleges, so that there could be the improvement into the efficiency, innovation and the academic excellence. Even the UCG is wanting to promote this, but the universities, due to their hierarchical position at the highest top position, and also they control these colleges, that's why they are not ready to give these colleges the autonomy. So we will study under GS paper 2 education sector again for the mains, and in the last we will study the urban water system into the context of the Bangalore facing the water scarcity. So it could be help. It can be very beneficial for the GS paper 1 water resources under the geography. It can also help into the disaster management, because the water scarcity and the water flood, the flood situation is part of the management, disaster management too. Again, it will be for the mains. So let's start with the front page. This is talking about the government to record the parents' religion to the register board. Okay, so here we will see that now there will be a separate record of the mother and the father and their religion. It is implemented for the adopted children as well. Okay, so what is the act that is providing such thing? So it is done under the Registration of the Birth and Death Amendment Act 2023, and this will be further, it will be added to the digital record, so that it can be added into the other areas such as the National Population Register, Aadhaar, electoral rolls. This data will be used into the all these area, and that will be available into the digital form, and where it will be recorded, it will be recorded on the platform that is known as the Civil Registration System. This is the crsorgi.gov.in. So please remember this. This digital board certificate will be issued, and it will be used for the even for the your admission. And this digital birth certificate that will be valid for the everywhere. Generally, till now, what we were using? We were using the class 10th result as the birth certificate, but birth and death certificate now there will be the separately registered, and that has been made the mandatory. It is done under the Registrar General of the India, and it comes under the Ministry of Home Affairs. So please remember, for the prelims, in the prelims they can ask that Registrar General of the India, it's come under the Home Ministry or the PMO or the Ministry of the Finance or the Defense Ministry. So you should know that it is the Ministry of Home Affairs. And here they are also going to bring the updated MCCD. This is the medical certificate cause of the death. Here not only it will register the cause of the death, but it also registered the history of any illness. History of the illness, if any, that will be registered. So there will be the two part. One part will be statistical and other for the legal information. So this religion will be under the statistical part, but the legal information include the Aadhaar number, mobile number, email ID. But this religion, that will be under the statistical. Even the address will be under the legal information, and there will be the minute locality will be asked. For example, they are going to ask even the ward number. Okay, ward number, house number, and the localities. Okay, so this will create a national level of the database, and it will help into the whenever we have to use on the different level. So you should know that this civil registration system, that will be the ground level implementation body. It will be appointed under the panchayat level, and at the state level, chief registrar and the registrar appointed by the state government, and they will be responsible to the Registrar General of the India. So this is all about from this news. Next news that is talking about again the electoral bond, who have received what amount. So here we have seen that due to the 7.5 cap violation, though previously it was there that if any company is not getting benefit, that company cannot fund for the elections. Even if any company is earning, it cannot fund more than 7.5% of their income. So this was the thing, but now we have seen that this time under the electoral bond scheme, we relaxed all this thing, and there has been so much corruption under that. Again, on the front page, the Kacha Thieu news is consistently into the news, and it is under the Sri Lanka. Sri Lanka is talking that this matter has been settled. So why the India is again bringing it onto the public domain? So this is not good, and yes, this is not good for the relationship between the India and Sri Lanka. Already we have discussed, we will not go into the detail. And one more political news that is from our Union Minister Nitin Gadkari. He is saying that the BJP will further reach to the southern state and the southern region. So this is all about from this front news. Next important news that we are going to take is the revisit these sections of the Bharatiya Nyaya Samhita. This is on the editorial page, and this is the main article. So revisit these sections of the Bharatiya Nyaya Samhita. Okay, so this is the main article, and the writer is the archivist, a former Indian Police Service officer. So here we will see that how there has been the change that has been brought from the Indian Penal Code. Already the previous act was the Indian Penal Code, and now it is the Bharatiya Nyaya Samhita. So revisit these sections of the Bharatiya Nyaya Samhita. This is the new code that was previously known as the Indian Penal Code. Okay, so Indian Penal Code had turned into the Bharatiya Nyaya Samhita, BNS. So please remember this. There has been the many of the laws, many of the provision that has provided in that has controversial. Okay. Recently we saw that there was the huge protest from those drivers of the truck and the other such vehicle. They were opposing section 106 of the Bharatiya Nyaya Samhita. And why it was being opposed? Because it provides for the 10 years of the imprisonment if there is any accident and the driver is not going to report that and it's escaped that. Generally what happens whenever there is the there is the accident, what happens? The people suddenly, without any investigation, they think that this driver is the main culprit, and they many a times there is the mob there is the mob violence, there is the mob lynching of the drivers. So generally the drivers escape from the place where the accident take place to prevent and protect themselves from the mob violence. So this is the one thing. Already there was the huge protest, and the government has stayed the implication of this section. When it is going to be implemented, whole the Bharatiya Nyaya Samhita, as per the government, it is going to be implemented from the 1st of July. So please remember this. Okay. The other area where there is the confusion, there is need for the review. The one is the petty organized crime that has been provided under section 112, 112. Okay. Other provisions such as the theft under the section 303, here it has been provided the amount of the theft if it is less than or equal to the 5,000 rupees, there it will be considered at the non-cognizable offense. And other area where need to be reviewed, human trafficking section 143. So these are the area where a proper review is needed, because there are so many lacuna. There is the legal interpretation where it cannot be justified on the ground of the fairness and reasonableness. Okay. So, what is the main issue with the section 106? First thing is that it has increased the imprisonment from the 5 to 10 years. The second thing is that it is talking about only when those victims who died. Okay. So it is not talking about even the aid that is needed to be provided if there is the accident happens, because this aid at the first hand, at the very initial stage of the accident, considered as very important, because it is very crucial factor that plays to save the life when there is the accident. So this is missing. The third thing is that the Article 20 clause 3 of the Indian Constitution that talk about that it prevent any person from the self-incrimination. What is self-incrimination? Means you are giving witness against yourself. This is not possible. This has been prevented under Article 20 clause 3. So let's see that what is the clause 20. It is the fundamental rights, and it's talking about the protection in respect to conviction of the offense. And the clause 3 talks about that no person accused of any offense shall be compelled to be witness against himself. So this is the clause here it is given. So please be very clear about that. It has been prevented against the self-incrimination. For example, you are convicted in the sum of the case, and in the judiciary you are going, and the lawyer is asking the question that asking that you have to accept your offense, and you have to say that yes, I was the main culprit. So in that condition, even if you decide to don't speak anything that is justiciable, that is acceptable, you can keep silent, you can speak nothing if you think that that can be used against you. So this is the thing that is considered as the self incrimination. So you should be very clear. These are the area that is going to be violated by this thing, by the Article 106 clause 2. Okay. Article 20. So this is the no retroactive law. Okay, so here no retroactive law. No person shall be convicted of any of the offense if that is not crime at the particular time when that particular events happen. That particular offense, if it took place at that particular time, there is no law to punish for these activities. For example, if on the 5th of the January 2020, if the breaking, if destroying a particular field that is of the maize field, or leave everything. If on the 20th January 2020, if breaking this pen is not a crime, this is not written in any of the law book, and on the 21st of the 2021, 21st January of the 2021, the law was made that if there will be the 1 year of the imprisonment if anyone will break this pen. Okay. If I broke this pen on the 20th of the 2020, if at that particular time when there was no law, so I cannot be punished into the 2022 or 23 that the law was made into the 2021. Are you getting the? When I broke this pen, at that particular time there was no law for the breaking the pen. This law comes into the 2021, but I broke this into the 2020. In that case, I could not be punished. This is known as the no self no retroactive law. Means you cannot go into the past and you can give the punishment for the activities, that action that has been taken. Okay. The second clause talk about the protection against the double jeopardy. Means already if a person has done some crime and there has been the trial and he has been punished. Okay. I have already been, for example, in the 2017, if I did some crime, if I did some of the crime, for example, I cut the trees that is into the forest area, and for that there is the there is the offense, that is the punishment. There is the punishment for this offense for the 6 month of the jail. Okay, so I cut into the 2017, and at that particular time the law is that I will have to go for the 6 month into the imprisonment. Okay, I was punished for the 6 month of the imprisonment, but into the 2003 some law was changed and it was made for the 2 years. So it doesn't mean that the case will again opened and I will be tried for the new law that was framed into the 2023 or 2022. Are you getting the? You cannot be punished for the same whatever the change that has been taken place. Even if there is the more grievance activities that has been found, I doesn't only cut the 2 trees if it is found that I cut the 5 trees. But already I have been punished for the same crime. I cannot be punished again. Okay, are you getting the what is the thing? If there is the increase in amount of the grievances, okay, increase into the amount of the intensity. Despite all this thing, I cannot be punished. So this is the ground. Okay, so you should be clear about this. And right against the self-incrimination means I cannot be forced to become witness against myself. Okay, even okay, you have the right to remain silent and not say anything that could be used against you in the court of law. So this is the my power. So here this law is talking that the person have to go and they have to report to the police official. Okay, even the Supreme Court has declared such a stand that of the incrimination as the unconstitutional, and even it has widened the area of this self-incrimination into the Nandini Satpathy versus PL Dani case. So please remember this case, this is very important. And in this case, the Supreme Court said that the compelled witness and testimony goes beyond the evidence procured not merely by the physical threat or the violence, but even by the psychic torture or overbearing and intimidatory method and the like. Means even if the psychological pressure is created to give the witness against yourself, this is against the law. This is unconstitutional. This is not legal. That has been given, that order has been given into the Nandini Satpathy versus PL Dani case. Okay, so please be very careful. Next thing comes is the petty organized crime. This is mentioned into the section 112, and this is related to the Indian Constitution. This is related to this Bharatiya Nyaya Samhita. Okay. So here it involves the various crime as a part of the group or the gang. If you have a gang or you are a part of the group or the gang and you have done crimes such as the theft, snatching, cheating, unauthorized selling of the tickets, gambling, selling public examination question papers or the similar act, then there will be the punishment and similar act. Okay. And there has been the lack of clarity on the unauthorized selling of the ticket, what is meant by them, or what is meant by the selling of the public examination question. This has not been defined in a proper manner. Okay. And the phrase that is the any other similar crime act that has been mentioned under this section, this is vague and open-ended. There could be the different interpretation that this act should be considered under the theft. Okay. So, for example, if there is the no definition, if any of the misconception, like the if we are going into the same bus and if there is the exchange of the your luggage with the my luggage, so this will be considered as the theft if this is not defined. There is the clear-cut definition that what is theft. It is the exchange of the luggage will not consider as the theft. Are you getting the what is the difference between the this clear-cut definition, how it can create the vagueness and open-endedness. Okay. Further, there has been the different type of the punishment. For example, theft and snatching can lead to imprisonment up to the 3 years. There has been the 7 years imprisonment for the doing the theft into the dwelling house or mean for the transportation can result into the 7 years of the imprisonment. Okay, so there has been the cheating can be result into the imprisonment from the ranging 3 to 7 years. Okay, under the section 318, section 307, all that has been there. Okay, the range of any other similar criminal act is unspecified, and beside that there is no certainty of the maximum sentence. Okay, despite there is the 7 years that had been given. So here there is the definition that the sentences can be from the 2 to 7 years. But in the eve of all this crime, the sentencing has been the maximum for the 7 years. So again, here is the vagueness. Why you are talking about the 2 to 10 years, while the act and the crime you are talking above under the petty crimes that has been defined under this section 112 has been defined the maximum sentence of the 7 years. Again, there is the vagueness and there could be the different interpretation, and by that the Supreme Court can declare it unconstitutional, and such declaration has been seen into the section 66A of the Information Technology Act of the 2000. Okay, and here into the Shreyas Singhal case, versus Union of India, this 66A of the Information Technology Act of the 2000 was declared unconstitutional. So please remember this Shreyas Singhal case is very important, and this section 6A was considered as a very vague and it was misused by the police in the so many instances, and in the last 2015 it declared as the unconstitutional. Again, the other area that there is the confusion and that can be questioned into the Supreme Court or the higher apex court for their vagueness. Here it is the property theft a specific value. Okay. So here it has been considered that if there is the theft, that the value of that particular asset under this theft is lesser than 5,000, then it will be not considered as the cognizable act. Okay, so it will be not considered as the cognizable act, and if there is it is non-cognizable act, in that case FIR is not mandatory to be filed, and that case police will not go for the surveillance or the investigation. So in such cases it will promote such petty theft, and here the writer is talking about this 5,000 that is considered as the low value for a well-off person into the city, but if you will consider it into a very poor person or the wage workers or the daily wage laborer, this amount is very large. If a person is earning 200 on a daily basis and after 20 days he is able to collect the 4,000 rupees. Okay, not even the 4,000 rupees, because there is expenditure on a daily basis. Even after a month of the saving, it will be 5,000 rupees, and there is the theft, the situation of the person. because he cannot go into the police and cannot ask for the police do that, because it has considered as the non-cognizable. Okay. Beside that, there is the confusion with respect to the when there will be the again the same person will be caught into the other stolen or the other crime, and it was found that he also did the theft of the value lesser than 5,000. So in that case, what will be the punishment? That is also confusing. So it has been questioned here that this 5,000 5,000 could be the low value for the well off, but for a normal people or for a poor people it is very high amount. Even it has given the writer has given the example of the for a student bicycle, despite it is of the 3,000 4,000, but it has a lot of value, because the child who has this bicycle, it help in his proper attendance into the his college, because it make him to attend the college in a more comfortable and more convenient manner. And again, to buy, if it has been given by the different government scheme, so it will be very difficult for the person or the child to get again this bicycle. Okay, so how it is going to impact the whole future of that child if the cycle is being theft? Okay, despite this, the value is low, but the importance is very high. So all this thing has been mentioned. Beside that, there is the mention of the no discretion into the sum of the cases. For example, there is the case of the trafficking, human trafficking, and that has been mentioned under Article 148, Section 143 of the Bharatiya Nyaya Samhita, particularly the section 6 and 7, and it's talk about the punishment for the child trafficking and trafficking by the public servant or the police officer. Here it has given. So in that case, there is the fixed amount of the punishment that is given, but this fixed amount of the punishment is not justifiable on the ground of the fairness. For example, previously into the Indian Penal Code there was the a section 303, and under that, if a person is life convict, means if a person is already in imprisonment with the imprisonment for the life, this is the sentence that already he is facing. But during this, he comes on out of the jail on the parole, or inside the jail itself, he killed someone, he murdered someone. So in that case, the punishment was only one punishment, and the death sentence. Okay. So here again, it was declared as the unconstitutional, because the Supreme Court find that it is not giving the judiciary with the its discretionary power, because many a time the killing could be the circumstantial. There could be the sum of the ground where the person who is life convict was forced to do the murder. For example, if some person is facing the sum of the sexual harassment and he killed in that case, so here the judge can justify that the death sentence not given, there should be the chances that he will be given the life imprisonment. Okay, so here if there is the non-discretion, so the judge cannot bring the fairness to the judgment, and that will be not justiciable or constitutional. For example, if there is the death sentence and without any fairness, or that should be brought under the circumstantial cases, so in that case it also violate Article 21 of the Indian Constitution, and that's talk about the right to life and the liberty. You do not go and investigate it the circumstances under that the killing was done. Okay, so here the case you should remember, under that the Supreme Court declared this IPC section 303 as the unconstitutional. That was the Mithu versus State of Punjab case 1983. Okay, so please remember the same type of the here this subsection of the 6-7 of the section 143, again it is the it doesn't provide the discretionary power of the judiciary, and that's why there is the chances that this section also can be declared as the unconstitutional. So all these things need to be reviewed, and if the government want, before going into the legal battle, can review and make the needed amendment. We can solve, we can write a answer on a same topic, and yes, please write it. We have provided the answer approach as well as the model answer. So the question is that discuss the significance of judicial discretion into the criminal sentencing with reference to the historical context and the legal developments surrounding the section 303 of the Indian Penal Code and its reincarnation as the section 104 of the BNS. Assess the implication of the absence of the judicial discretion in the certain provision of the BNS, such as section 6 and subsection 7 of the section 143. 150 words and 10 marks. So please write. How you will write? The first, it has already made clear that discuss the significance of the judicial discretion. So you can start with the defining what is the judicial discretion and what is the significance of the judicial discretion, because it gives the judgment, the judges, to bring the circumstances under that this crime or this event has taken place, and whether the gravity, the intensity is at the what level. As per that, the judges can vary their sentences. Okay. Then you need to bring the historical context of the section 303 of the IPC. You can brought the Supreme Court judgment under that it was declared unconstitutional. Again, you should bring this section, how it has been changed to the section 104 into the BNS. Under that, there has been the flexibility that the judge can punish with the life imprisonment as well as the death sentence. So this section 303 has been changed and it has been modified into the Bharatiya Nyaya Samhita. But the Bharatiya Nyaya Samhita has the one area where it has not brought the discretion, and it is lacking the discretion to the judges, and it is the subsection 6 and 7 of the section 143. So here there is need for the review. In the last, you can conclude with the suggestive note that yes, there is need for the review. Otherwise, there could be the legal, constitutional, and other such interpretational hurdle. So before it is going to the legal battle, the government should review, and there should be the solution for this section. So this is all about. You can bring such, or you can write this answer. You can self-assess by the matching with the points that has been provided under the model answer. This is from this is all from this news article. Next important news that we are going to take is again from the editorial page. The first editorial column, it is talking about the overkill. So what is to overkill? Overkill of the EVM system and the demand of the VVPAT is going to defeat the purpose of the EVM. That is the discussion part of this article. So it is talking, before entering into this discussion, we should know that basics about the VVPAT. So what is the VVPAT? It is the verifiable data, and this is counted by the paper whenever you go for the voting. What you see that whenever you place the symbol of the candidate of a particular party or the independent candidates, you find that there is a paper, and that paper will show the name of the candidate and the symbol, two things. So please remember, the name of the candidate and the symbol, that will be the reflected to you that whatever you have voted, this is going into the same manner. There will be the series number as well, but mainly it is the candidate name and the symbol that is the focus point. Okay. It will be there for the 7 seconds, and after 7 seconds this will fall into the box, and that will be stored there so that we can verify later. So this is the VVPAT. How the VVPAT, how many number of the VVPAT is counted? In a one assembly constituency, there will be the 5 electoral booths. From that, the VVPAT, it will be counted. So not 100%, near about the 5%, 10% that could be. So this is the position. The demand is that for the 100% count. So 100% count is not possible because it will increase the administrative cost as well as it will delay the timing. Beside that, it will defeat the purpose of the EVM, use of the EVM, because electronically counting the numbers, the voters' numbers is very easy, but counting the slip one by one will consume lot of time. So it will defeat the whole purpose of this use of the EVMs. The second thing is that there is also question on the use of the VVPAT, that it compromises the overall security and the privacy of the voters. For example, this VVPAT will increase the administrative cost and so many logistic hurdles. Beside that, it is possible that those who are going to hack the EVM, they will hack the VVPAT as well, because it is connected to the EVM, and they can manipulate the program in such a manner. You will vote on some symbol, the VVPAT will show the same symbol and the candidate, but the vote will go into the actual manner of this EVM to the some other candidate where it has been programmed. Okay. So this is the question, but this is not possible because even there is a verification by the VVPAT. So this is not possible because later there will be the counting. So instead of going for this exclude or the give up this VVPAT or the going for the 100%, what we can do, instead of the 5 electoral booth, we can increase the number, we can increase the percentage of the vote. Maybe it could be the 25%, because we have seen that there has been no cases, the proof cases of the hacking of the EVM. Mostly in the some of the glitches that has been found, it has been the minor glitch and that has been immediately rectified by the election commission. Besides that, during the verification there has been the no error, meaning very few minute errors, such as the error, for example, the error such as the when that particular voting EVM is going to be used, before that there is the checking of whether this is working or not. So one or two vote they try to register, they try to give by themselves. By that particular time, they forget to delete the same. So they can be count this extra, the checking away, while the checking this one or two votes could have been the count. So these are the minor error, no, not the major error. Okay, so this has been there. So the better solution for all this is to go for the higher number of the VVPAT confirmation instead of going for the 100%. Okay, so increase the recount of the sample size, not the 100% or the not going to give up this VVPAT. So this is all about from this editorial article. Next important news is again from the editorial. This is talking about the recent tournament that is going to be happen into the Toronto. So it is just precursor of the World Championship, and whoever will qualify, they will be the participating into this World Championship. So this is talking about the Toronto. So here, who are the main contenders? So the previous winner, Ding Liren and Zhu Wenjun. So this is the Ding Liren and she is the Zhu Wenjun. She is from the China. Both are from the China. They are the more contender. From the Indian side, there has been the 5 player that is going to be going to participate, and it is the largest number of the contenders, because out of near about the 16 contenders, 5 are from the India. So here you can see. And who are the 5 plus 3 from the men's side? So here you can see Pragananand, D. Gunesh, D. Gukesh and Vidit Gujarati. So here the 3 male contender and 2 female, that is the Koneru Hampi and R. Vaisali. So Koneru Hampi, she is the most experienced. She has the very large experience of this chase, and V. Vaisali, she is the elder sister of the Pragananand. So you should remember. From the Indian side, we have seen that only Viswanath Anand has represented India into this prestigious event, and he has been the winner of the world champion for the 5 times. Okay, the other contender, the Arjun Irigasi, he is not participating into the tournament. Okay. Beside that, the other strongest player of this tournament is the Fabiano Caruana and Hikaru Nakamura. So here the both players, their pictures are here. And Magnus Carlsen, he is the world champion, current world champion. So you should remember that he is not participating into this tournament because he is not motivated. Someone need to motivate him. Only then he will contend. Other important contender, this player, the Ian Nepomniachtchi. So he is from the Russia. He could also be giving very strong fight. And other one is it is from the Iran. He is the Iranian born, the French player Elireja Firouzja. So please remember all these players, and what could be the possible outcome we will see into the when the result comes. So this is all about from this news article. Next important news that we will take is the university must buzz on the college autonomy. So here the college autonomy that is being promoted by our national education policy itself from the 2000. So here it is being discussed that how the autonomy to the educational institution, the colleges, promote the innovation and also the self-governance and the academic freedom. So academic freedom means they can choose whatever the course they want, whatever the syllabus they want. There could be the change as per the need. For example, if some college that is situated around a farming area, agriculture dominated area, for that they can promote in their syllabus and their course the food processing industry. Maybe the people need the agriculture education, the education after the whatever the product that is coming out of the farming and agriculture. So all this thing can be changed. So here the autonomy is very important. Okay, and we have seen that UGC has continuously promoting this autonomy by its regulation, and there has been 590 colleges that has made the application for the autonomy. We have seen the change and the outcome of providing the autonomy, because we have seen that out of the 100 top colleges by the NIRF ranking, this NIRF ranking that is done under the Ministry of Education, there has been the 55 colleges that is from the autonomous institution. So there has been the excellence that has been shown by this autonomous institute. Out of 10, there is the 5 colleges that are the autonomous. This shows the result of autonomy, and most of the state they aspire for the more autonomy to their colleges. For example, 100 application has been there, and there in the future there could be the expectation that 80% of the total colleges into the Andhra, Karnataka, Maharashtra, Tamil Nadu and Telangana, this southern state will have the autonomous college. Okay. But the one issue that is faced by these colleges in getting the autonomy and autonomous in status is the reluctance from the universities. They are not ready to provide the autonomy. They try to control the different area of the colleges, such as the course, syllabus. They cap the changes the colleges can make. Okay. They do not give the freedom to choose the new designed courses or any of the syllabus, because there is the tradition of keeping into the higher at the hierarchy. For example, there is the affiliated college from the some of the university. So university feel at the top of this hierarchy. We have the hierarchical system, and that reflect into the institution as well. There could be the question into the essay paper that this hierarchy into the society not only reflected into the people and the society but institution as well. This is a very good example. Here the college and university feel that they are at the top of the hierarchy on the governance. Okay, and that's why there is the other such misuse and inefficiency, such as the providing the affiliation. These universities take a lot of the fee as well for providing the affiliation. So arbitrary fees are imposed. Okay, so these are the things that is needed to be rectified, and for that we need to the State Council of Higher Education. They should work as per the regulation for the implementation of UGC regulation. There is need for the collaboration with these college and the universities, but only after the autonomy is provided to the colleges, and only it is due to the increase the efficiency. Because if there will be the separate autonomous college, there will be the they will be made the responsible and accountable if they are not performing well. Otherwise they will finger out to the those universities at the top that they are making the syllabus, why you are asking for the us. But as the affiliation and autonomy will be given to the colleges themselves, they will feel that they have to be accountable, they have to be more transparent, because they have to make syllabus and they have make to the courses. They have to prepare all these things, all framework. Okay. This is needed because beside that the teachers of those colleges, they will be feel the pride if the performance is better, because they think that it was our creation, and that's why there is the chances that they will work harder and there will be the better outcome. So this is all about. And further, if autonomy is given, so there is need for the collaboration. Yes, wherever the college feel that yes, we are lacking into the some area, they can collaborate with the universities. So collaboration between the universities and autonomous colleges are essential for fostering the innovation and academic excellence. So these are all these things that has been discussed under this article. Next important news is with respect to the water scarcity across the India, and this is in a specific case of the Bangalore, where we have find that there is the extreme case of the water scarcity. People are waiting for the 5 days, 6 days to get the water. This is the situation into the Bangalore. Why? What is the issue? This is the water scarcity or the management or what? Because there is the condition that this southern area was once a time there was the full of the forest area and the water was into the plenty. But the situation is now, even the Central Water Commission, this is the body that works under the Ministry of Jal Shakti, and it has into the report. It is the technical body. It provides the guideline. It collect the data across the water, different water quality, different water resources. What will be the water level, quality, different thing. Okay, so this water bodies, this body have given the data that for the southern area, the reservoir of the southern area have the only the water of their 23% of the total capacity. For example, if this area have this water reservoir, think that this is the water reservoir. This is the 100% capacity by this layer. But the situation has now been that they have only 23% of their capacity. Now the water has reached to that level. And in the many of the reservoirs that has dried up. Okay, so this has been the reduction. Okay, this is the reduction into the water body. What is the reason? Because if you will see that the condition of this Bangalore, it was not that. So there is the interview on this matter that what is the condition, why does such issue is there. Two experts are there that have given the reply. TV Ramchandra, he is the coordinator of the Energy and Wetland Research Group, that is at the Center for the Ecological Science at the Indian Institute of the Science. The second person is the S. Viswanathan, he is a water conservationist. Okay, so please remember this thing. So let's see that what are their views on this. The first thing is that they have mentioned that if you will go through the history of the Bangalore, you will find that in 1800 this Bangalore had the 1452 interconnected water bodies. So there was the interconnection so that they could have the The plain is if there is the water surplus in one water bodies, that would have been transferred to the other bodies. But the situation is now that the situation has reversed. Instead of the 80% of the water bodies, now 86% of the Bangalore has the pavement, concrete pavement, the roads, the different type of the buildings, all have been the concretized. This is the issue, and the green cover now is only 3%. Okay, so this is the issue here. It is given. Okay. You will find that now the water resource of the Bangalore, that is fulfilled by the first the groundwater and the second by the Kaveri river. The situation is that in the Kaveri river, that has the 50 to 60% of the water supply that supply to the Bangalore. Previously it has the lot of forest coverage, but there has been the loss of 45% of the forest cover of this Kaveri river, where its catchment area was there, and now it has shrink only to the 18%, and 75% of this is the now agricultural area that need the water for irrigation. Okay. So water supply and this all has been shrinking due to this water resources is reducing. Here you will see that the watershed and the Kaveri catchment area. What is the watershed and what is the catchment area? This is the conceptual thing, so you should understand. Think that this is the a region. This include the village, fields, everything. And here, if this in this region, if water is falling anywhere, this is flowing toward a common resource. Common source that could be a large lake, or it could be a river. So here, from the point where the water is flowing to the a single water resource, that is known as the watershed. So what is the difference between the watershed and catchment area? Watershed. What will be the catchment area? Watershed is a part of the catchment area. So this is the one area. There could be the other watershed area here. The water could have been falling into this river, and this all water falling into the resource that must have been connected through a common body. This whole area will be known as the catchment area. For example, there is the UP, Bihar, like the other states, and if you will include all states, so this will be a country, and country name will be the India. Same is like the all the watersheds, they are the like the small states, and the whole area, catchment area, will be the like the country. So this is the concept you should know. So this is the one region. Other region is the climate change. Climate change is the other cause of the reduction into the water resources, and there is the lack of the common encompassing all the resources of the water source for the water supply. Maybe the water supply can be possible by the pipeline, as well as the rainwater harvesting, water and rainfall that is falling, that can be collected. There could be the use of the surface water such as the lake, river. Even the wastewater can be recycled, and that could be used for the supply of the water. That will reduce the water scarcity into the such areas. Okay. Besides that, we see that there is need for the understanding of the city catchment area and the resources, and after that a proper management into the integrated manner, only the solution could be there. The other thing is that the question comes that this in the same city, in the sum of the month, maybe into the January, February, March, April, there is the water scarcity. In the same city of the Bangalore, into the August and September, there is the flood condition. Why? Because there is the mismanagement. For example, they are not managing their construction in a proper manner. Take the example of the road construction. The road they are making in such a manner that create the barrier of the water flow. For example, think that there is a river that is flowing from this direction to this direction. This is the river that is flowing from this direction to this direction. Without thinking about what will be the impact of this river, they will construct the road here. Just with the narrow thinking, narrow perspective. What will happen? This water source gradually will sink and that will be dry up. Shrink and dry up. This will be the condition. So such type of the not properly thoughtful construction is the cause of such thing. Okay. So what we need to address this thing, a proper integrated governance. Now we see the fragmented governance. One example of the fragmented governance you must have seen. If you are living in the some of the colony into the any of the major city, you will find that in some of the month there is they have dug the road. And if you will ask that why they are digging this road, they will say that due to they are laying down the wire for the internet, maybe Wi-Fi, maybe for the LAN. Okay. You will find that okay, after 1 month they have digging, they have destroyed all the road. After that they will fill up, but that is not so much in a well manner. There is always some of the deformation that will come into that road. After 6-7 months, again you will come into that area, you will find that again they have dug the road. You will ask that why they have dug. They will say that they are laying down the sewage line. Okay. After 6-7 months again you will come, they will be digging for some other purposes. So this is due to the fragmentation. If all this authority, those who are laying down the sewage, those who are laying down the water pipe, those who are laying down the electricity wire or the internet wire, if they have the interconnection, proper cooperation, proper coordination, one time digging will just solve all the problem and it will reduce the inconvenience of the people. That is found into the most of the cities, and this is the thing that we need to resolve. Beside that, the new ideas, a sustainable ideas such as the sustainable development is possible if you are going to use some of the natural thing. For example, rainwater harvesting could be a very good solution, and the 70% of the Bangalore need of the water can be fulfilled by this rainwater harvesting. But this is not being done. Neither government is incentivizing by the some of the scheme. They are doing, but there is no dedicated implementation. Okay. Beside that, we need a better water infrastructure, and we also need to depopulate the urban centers. We need to, the question is that what could be the solution? Do we need to de-migration, reverse migration? Whatever the cities have seen, there should be the cities, the population should be reduced. Yes, there is need for that. Clustering is needed on the outskirt of the city. Okay. Beside that, efficient manage of all these water resources into their cluster is also needed. So both are needed. Only the reverse migration is not the solution, but yes, there should be the increase into the water resource and the efficiency of the water resource. Okay, so all this thing is needed. Okay. Beside that, what we need to improvement on the urban center, and we should shift the focus areas to the river basin, and there should be the interconnection again and again. The thing is that you cannot just focus on the one picture and you will ignore the holistic picture, because if you are not going to think about the river basin, only focusing on the urban center will not solve the problem. And such recommendation has also been given by the Gadgil and the Kasturi Rangan report, but the government didn't accept the suggestion and recommendation. So what we need active citizenry as well. We should ask our government that what type of the planning you are doing. Beside that, we need to elect a very much honest and those efficient leaders, those who can bring the transparency and accountability. Well, it is possible that if you will elect the good leader, those who have the honesty and integrity, and only then knee-jerk type of the reaction that whenever there is the flood, they will go for the different relief and risk operation. They spend a lot of money. But whenever it comes that everything is now resolved, then there is the planning is needed. They do nothing at that particular time. So instead of knee-jerk reaction, what we need a proper planning, and the planning should be in such a manner that it addresses the long term and it brings the long term and the sustainable solution. Okay, so this is all about from this news analysis. This is very important. They can ask into the GS paper 1, because here into GS paper 1 there under the geography section there is the resources, and in the GS paper 3 there is the disaster management. So there has been the need of the there has been the disaster management condition due to the flood as well as the water scarcity. So this is very much interdisciplinary. You need interdisciplinary approach whenever you are going to write the answer. So this is all about from this news analysis. We have covered most of the relevant area. Let's do the sum of the question from the prelims so that we could have the we can know that what is our level of the retention. Just solve one by one. The first question, in a cognizable offense, which of the following action can the police take without the obtaining a warrant? Arrest the accused, search the premises of the accused, file a charge sheet into the court, seize evidence from the crime scene. So here you will read that it is only the arrest of the accused that is possible. In the other cases, they need the warrant and the legal procedure. Which of the following offense is the most likely to classify as the non-cognizable? Robbery, assault causing minor injury, kidnapping, dowry death. So here you will find that the robbery, by reading you can exclude, dowry death you can exclude, the kidnapping you can exclude, only the lighter crime, that is this minor injury, that could be the non-cognizable. Question number 3, identify the primary legal document that define the classifies cognizable and non-cognizable offences in India. Indian Penal Code, Constitution of India, Code of Civil Procedure and Code of the Criminal Procedure. So here the answer will be the Code of Criminal Procedure, that bring the legal procedure, that how you have to follow all these things. The punishment directly mentioned into the IPC, but the procedure for how you have to proceed for the crime and other activities, this is mentioned into the Code of Criminal Procedure. Okay. Question number 4. Article 20 of the Indian Constitution guarantee protection against ex post facto laws, double jeopardy, self-incrimination, all of the above. So you will find that under Article 20, that is provide the protection against the arrest. It provide the prevention from the ex post facto laws. Means if the laws has been made later and you have done same thing when the law was not there for the criminalizing your activity, you cannot punish. This is the ex post facto laws. Double jeopardy means you cannot punish for the same offense for the 2 times. You have done a theft already. If you have punished for the 1 year, it is not situation that again you will be punished for the 1 more month. Okay. And self-incrimination is also prevented. It means that whenever there is the crime, you have done some crime, it is not that you will be made the evidence. You can even keep silent whenever something is asked, because if you think that this is going against me. So self-incrimination is not promoted and it is prevented under Article 20. So all the above will be the answer. Question number 5. Which article of the Indian Constitution is often considered along the Article 20 when discussing the right of an accused person? So here you will find, whenever we talk about the Article 20, that protection against the arrest, it's talk about the right to liberty and the life. You cannot be jeopardize your life and the liberty, and there should be the fair procedure for all these things, and that the arrest also should be the fair. So it will be Article 20. So you will find that the Article 21 has the lot of scope, and it has been interpretation by the judiciary. It has been expanded in a very wider manner. Question number 6. What is the primary purpose of the VVPAT system? To prevent the multiple voting by a single person, to increase the speed of counting votes, to allow the voters to verify their vote was cast correctly, to provide an electronic record of all votes cast in the election. So here you will find it provide an electronic record of all votes that is cast into the an election. So D will be the correct answer. and also it is to give chance to the verify the voters that their votes was cast correctly. So it will be the C will be the correct answer, because yes, you will watch what is the process. Whenever you will go, you will push the button. So there will be the name of the candidate on that paper and also the symbol, and it will be visible for the 7 seconds. So this is all procedure. VVPAT was first introduced in India during which of the following? 2014 Lok Sabha election, a by-election into the Nagaland in 2013, 2009 Lok Sabha election, 2019 Lok Sabha election. So you will find that this was introduced by the court order under the Subramanian Swamy case 2013, and at that particular time there was the by-election into the Nagaland. So it was first implemented in this election to test whether we can implement, and further it was implemented, and at the full scale it was implemented into the 2019 Lok Sabha election in the Lok Sabha election. Last question, question number 8. Which of the following is true about the VVPAT slip? VVPAT slip contains the name of the voter? No. VVPAT slip remains visible for the voter for a few seconds? Yes, it is for the 7 seconds. The VVPAT slip can be taken home by the voters as the proof of their vote? No. There is the box, in that box that will be stored. You cannot touch even. The VVPAT slip can be used to challenge the election result of the court? No. This is not necessary that you can know that whether whatever you have voted that has been counted or not. There is the random selection of the 5 of the electoral booth of the each of the state legislature constituency, this assembly constituency, and from that there is the verification. So this is not fixed. So the correct answer for this is the B. So this is all about from the today's news paper discussion. We will conclude our session here. Thank you for joining the session. All the best. Jai Hind.